Now,
So,
what would it replace? Is this the grand jury?
that's exactly, and that's what it actually did, because we had grand jury and preliminary hearings before. Now the majority of our cases go by information charging, which you take a judge who is perfectly well aware of what probable cause is, who can do an excellent job of analyzing something both factually as well as legally, and sit there and say, okay, we're ready to have a trial on this thing, and then boom, you're off to circuit court.
I remember when you first brought this up and you got it passed, or how many years you've been bringing it before it was passed, and the defense attorneys were saying it's going to be awful.
It's going to be a catastrophe. The wonderful thing about this is, and there were some judges who thought the same thing, that we could now get a judge before you in a heartbeat who will tell you how much time this has saved. You defense attorneys who are in the private sector, they love it. It's only people who have lots of time on their hands and willing to waste it who want to go and have a system that's basically got a procedure that's useless. So it's very, very successful. It's actually being considered in some other jurisdictions because it's worked so well here. And now all we're asking is to catch up with changes in the law so that we can do it for more people.
And so is this statewide or just on Oahu?
It's completely statewide. It's a statewide system, and it's working. And the neighbor islands are doing a very good job of using information charging. And here on Oahu, it has completely replaced the vast majority of preliminary hearing and grand jury proceedings. We're now at the point where we're running out of grand jury cases, which is a good thing.
Wow, good. Mark, what else is there in your package?
Well, a very important bill, which is also, for the moment, going nowhere. There's a theme here.
Yeah, familiar tune.
Is a proposal to amend the Constitution, and let me kind of lay the stage for this. Let's say you have a rape case where you have two people who are going to testify. One is the alleged rape victim, and another is the alleged rapist. The victim is going to take the stand and say, "This guy raped me." The alleged rapist is going to take the stand and say, "No, I didn't." And let's say they both have been previously convicted of perjury, that is, lying under oath. The jury will get to hear of the fact that the alleged rape victim was convicted of perjury, but will not get to hear that the rapist has been convicted of perjury. Any witness who testifies in that trial, any prosecution witness, any defense witness with prior convictions for involving dishonesty or false statement, the jury is going to hear about it. But for the criminal defendant, they're not going to hear about it because 30 years ago our Supreme Court said it violates our state constitution in almost every circumstance for the jury to learn of prior convictions of a testifying criminal defendant. We are virtually the only place in the common law world that has that rule.
It just seems like there's no common sense.
It is no common sense.
And not fair play.
It isn't. When I started talking about this, I said that that everywhere in the world, almost every state, I think 47 or 48 out of 50 states, a couple of states don't allow convictions of anybody to come in. And I think that I said, yeah, you can't use them in Wales. But Wales changed its rule.
Oh, geez.
So I believe it used to be, I think you couldn't use them in England and Wales. Now you can. So now it's us. And again, there are a couple of states where no convictions come in at all. And one could make an argument that as long as the rule is the same for everybody, it's okay. But to me, the better argument is we let juries decide who's telling the truth and who isn't every single day. And for hundreds of years, our legal system has had the view that a conviction involving honesty is something a jury ought to consider in deciding whether or not somebody who's taken the witness stand is telling the truth. If you've been convicted of perjury, a reasonable jury might think it's more likely you're lying now. If you've been convicted of a crime involving dishonesty, a jury might find it's more likely you're being dishonest now. But our whole system is based on the ability of jurors to look at relevant evidence, that is, evidence that makes a difference in the case, sort the wheat from the chaff, and decide who's telling the truth. They do that every single day. They do a remarkably good job, but they can only do as good a job as the evidence they're allowed to hear. And to say we're going to allow them to hear about prior convictions of the victim, but we're not going to allow them to hear, or a percipient witness, but we're not going to allow them to hear about prior convictions of a criminal defendant who testifies, doesn't make any sense. We're not saying we want to just go in and argue to a jury, this guy's been convicted 10 times before, so he must be guilty. You can't do that. And you can't bring out the prior convictions even in the jurisdictions that allow it, unless the defendant testifies. And that's all we're seeking. Fair play, even-handedness, giving the jury relevant evidence both about the victim and about the defendant. It doesn't make any sense for us to have a rule in Hawaii in this instance that so favors criminal defendants and so disfavors law enforcement to make us one of the most difficult jurisdictions in the country for law enforcement. We say in the Law Enforcement Coalition over and over again, we don't want more favorable rules for law enforcement than is everywhere. We just want a level playing field.
Right. And so in order for a constitutional amendment to pass, tell us what has to happen?
Well, the legislature would have to decide by a 2/3 vote in the House and a 2/3 vote in the Senate to put it on the ballot. And then the people would get to vote on it in November. We know there are going to be constitutional amendments this year. We know there's a general election ballot. I think this would be a perfect thing to vote on. And again, the legislature could say this is something with virtually no cost, but it would improve the quality of justice in Hawaii. It's something that people ought to have the opportunity to vote on. We ought to have the opportunity to decide whether we want a more level playing field in Hawaii than we have.
Great. Peter, what else is there on your package?
Well, we've done this many years, and that is there's a murder bill out there. And instead of worrying about what people say, worrying about what they do. For years and years, we've always got the excuse of, oh, I didn't know that hitting that poor lady over the head with a crowbar was going to kill her, or I didn't know throwing her into the side of a wall full force was going to kill her. I just thought it was going to stun her or get her away from me. And so the problem is that we have a statute that focuses on what is the intent, what's going on in the head of the defendant. And the head of the defendant is sometimes not all that easy to be able to give unequivocal evidence as to what he or she is thinking. And so they've always got an excellent excuse at trial, which boils down to, oh, I really didn't mean to do that. I never thought I was going to kill her. Sure, I recklessly killed her. This is a manslaughter. But you can't convict me of murder, which would get her a life sentence as opposed